How New York Medicaid looks at your homestead. Medicaid often seems like a threat to family homes. Loved ones worry that nursing home bills will force a sale or that the government will seize everything. In reality, New York's chronic care Medicaid program does not automatically take your house. The state may place a lien during institutional care and may recover from the probate estate, but important protections exist for spouses and certain relatives. With careful planning, families can qualify for benefits while preserving their residence and other assets. A homestead can be a house, condominium, cooperative apartment, or mobile home. New York Medicaid treats it as a special asset. If you follow the rules, your home may be exempt and not counted for eligibility. Vacation homes, summer homes, and cabins do not qualify. For 2025, you may keep one homestead with up to $1,097,000 in equity, which matches the federal maximum for nursing facility and community-based care. When a spouse, child under 21, or blind or disabled child lives in the home, the equity limit does not apply and the residence can still be excluded. You may even sell and purchase a different primary residence, provided you remain within these rules. Several transfer exceptions allow you to preserve your home without triggering penalties. You may transfer the homestead to a son or daughter who lived with you for at least 2 years before you entered a facility and provided care that kept you out of a nursing home. A transfer to a blind or disabled child is also exempt. Transfers to siblings are allowed only if the sibling has an equity interest and lived in the home for at least 1 year before your institutionalization. Without an equity interest, the sibling's residence does not create a transfer exception. Buying a life estate interest in someone else's home is treated as an uncompensated transfer unless you reside there for at least a continuous year and the purchase price matches the actuarial value. These rules reflect federal law, and New York applies them to determine whether a transfer is penalized. New York's Medicaid reference guide views an expressed intent to return as enough to keep the home exempt, even if returning is unlikely. If you leave to a facility and do not expect to return, the state can place a lien. After death, it may recover from your probate estate unless a protected relative still lives in the home. Keeping equity within the cap and maintaining a protected resident or a documented intent to return helps preserve the exemption. A Central New York estate planning lawyer from our law firm can help you confirm your home's equity, who lives there, and whether you need to document an intent to return. Timing gifts and using tools like properly drafted trusts can maintain a roof over a spouse's head while ensuring the government pays for care. Resource limits in 2025 are tight but workable. For community Medicaid, a single applicant may have up to $32,396 in countable assets, while couples applying together can hold $43,781. Monthly income for home care is $1,800 plus a $20 disregard. If you enter a nursing home, only a $50 personal needs allowance is kept, with the rest going to care. When only one spouse applies, the spouse at home may keep at least $74,820 and, depending on circumstances, up to $157,920. The community spouse income allowance can reach $3,948 per month, with a minimum of $2,643.75 effective July 1, 2025. These figures shift yearly and represent a snapshot of 2025. An attorney can help you verify current numbers and structure assets so you meet the limits without losing practical access to funds. Understanding how New York Medicaid views your homestead is vital to estate planning. The program offers broad protection when a spouse, minor, or disabled child lives in the home, or when you have an intent to return. Transfers to caretaker children, disabled children, or siblings meeting specific conditions can occur without penalties. However, vacation homes are never exempt, and life estate purchases must meet strict rules. Because Medicaid rules change each year, working with a knowledgeable lawyer helps ensure compliance and preserves your most valuable asset. If you are considering transferring ownership or need long-term care, Speak with an attorney familiar with New York Medicaid's Homestead rules. A skilled Central New York estate planning lawyer at Davies Law Firm can review your situation, explain your options, and prepare documents to qualify for benefits. Our law firm has decades of experience helping families organize, preserve, and transfer wealth. Before making any changes to your homestead or other assets, consult a professional with the knowledge and experience to provide sound legal advice. To learn more about estate planning and how to qualify for benefits, we encourage you to attend one of our free seminars. Davies Law Firm is located at 210 East Fayette Street, Syracuse, New York, 13202, United States. To discuss your homestead and Medicaid planning, schedule a telephone conference today at 315-472-6511. Our attorneys are ready to help you protect your home and navigate New York's Medicaid rules.